Hello, it's Philip Taylor speaking from Richmond Green Chambers in London in the United Kingdom, and I'm looking at a book which has come to us from Australia, and it's a very important book which I found very intriguing, mainly because it involves what the title suggests, and that is Commonwealth Criminal Law. That's the title of the book, Commonwealth Criminal Law, and it's been written by Troy Anderson. It comes from a publication press called the Federation Press, and I'm going to show you the book first of all. It's a hardback. It's not a big book. It's blue cover. There's the front. There's nothing on the there's a spine. There's nothing on the back. The book is actually quite small in terms of its size, 200 odd pages. There's a useful index right at the back, which we'll start off with, and then if we move back into the main book itself, right at the end, the last section, that's actually the beginning of the index there. The last section is on extradition. Now, the way the book is structured, you've got paragraph numbering at the sides, which is a nice standard international way of dealing with things. You also have footnotes, but not too many of them, which is quite nice. And you've got some very, very useful case law across the whole of the subject matter. There is the front page there. You can see Mr. Anderson is a barrister and member of the New South Wales Bar. There has been a foreword by the Honourable Justice Geoffrey Bellew, which again is of interest. And what we have there is that is the actual foreword there, which sets out what in fact has been happening with the development, what he says is the considerable development of the criminal law as it applies to offences against the laws of the Commonwealth. Then you have the contents page there, running all the way through. You can see quite a lot of interesting subjects coming up, which will be relevant to this country as well as anywhere else. For instance, money laundering, proceeds of crime, counter-terrorism, child exploitation. Then at the end, sentencing, imprisonment and so on, and then extradition. Then there is a preface which Troy has written, you can see there, dated, just dated 2014. And he's dedicated it to his parents, which is very nice. I always like to mention the dedications. Then you've got some acknowledgements there from who's helped. Then you've got after that the table of cases, then table of statutes, and after that we then get into a whole range of the actual book itself and a whole range of the chapters. That's the overview at the beginning. Now, the reason we've reviewed this book is because, as it says here, the purpose of this chapter is to explain something of the unique character of Commonwealth criminal law, the relationship it has with state and territory laws, and the principal organisations that enforce it. And again, I think, as you will see from what I say with our review, that when we get into this subject, you will see how important the link is between the Commonwealth and perhaps what we do with our jurisprudence in England and Wales, just for one example. For instance, the Commonwealth DPP is mentioned there. And then the book itself runs through various offences and given there under the Corporations Act and various other matters. There's the book. As I say, it's not a big book at all. Now, my wife Elizabeth and I looked at this book. We had a chat about it because it was an interesting departure for us from what we normally would review, both for the journals that we write for and also what we put online and where we actually place what we've commented upon. And we gave the title for our review the following: For International Lawyers and Students 2, Practical Commentary and Guidance on Commonwealth Criminal Law. And that is what you're getting. And one of the start-off points is the fact that in many jurisdictions we are trying, even now, and it's a very gradual process, to try and harmonise some of the particular types of crime, for instance, that might be committed, because we are effectively now living in a global village. And that makes a big difference to the way in which we see the role of crime, perhaps, and the way we actually deal with people who commit crimes and what we recognise as a crime in the first instance. So we start off by saying, as we now live in a global community linked by the internet, business has gone global and so has crime. And as time moves on, so must the law. We've been a bit slow in catching up, but I do suspect that we will be catching up, and we will be looking as individual serious countries, not the ones where there are really serious problems, but the serious countries that are looking at law enforcement and the way we deal with the whole aspects of criminal law. We've got to look at it really more on the same sort of basis. So there's a playing field across the world about what we recognise as things that are wrong and things that are right, and in its simplest form. So what we then say is the problems of dealing with cross-border and international crime has been the subject of many a research study and a lot of books, many from leading publishers both in the United Kingdom and of course across the world. This book, which as I say comes from Troy Anderson, who's a barrister and member of the New South Wales Bar, we think is particularly important in that, as he explains, it's apparently the first book published recently, that is, to deal comprehensively with Commonwealth criminal law. That's how he starts off his book. This, explains the author, is criminal law as prescribed under the Commonwealth Crimes Act 1914 and Criminal Code Act 1995, the Code, of course from Australia. These are the two key pieces of legislation creating and dealing with Commonwealth criminal law to which the book refers. It also deals with the numerous criminal statutes which create offences, and has been published, as I've mentioned earlier, by the Federation Press in Australia, and the book covers, as the author explains, the general principles of criminal responsibility and many of those offences themselves. And there are indeed many offences created under Commonwealth legislation, a whole shopping list of them in fact, which is by no means exhaustive. They include, for example, offences that we would recognise clearly both within the United Kingdom, England and Wales and the European Union as fraud, including tax fraud, drugs importation, money laundering, copyright infringement, cybercrime, counter-terrorism, human trafficking and slavery, people smuggling, child exploitation, crimes against the environment and bigamy. And that's just naming some of the more well-known types of offence. Now the important thing to bear in mind here is that whatever type of word you use, we recognise those types of activity which are classified as criminal offences, and therefore what we're looking to do, as I said in my introductory remarks, is to have some form of harmonisation. And I believe and would submit that we might be moving very much more towards that, both within the EU and in the much wider world of the Commonwealth jurisdictions themselves. And it's always interesting from a UK point of view, and I include Scotland and Northern Ireland as well as England and Wales in that to be reminded that in Australia, for instance, failing to vote is also a Commonwealth offence, i.e. crime, as is failing to participate in a referendum. We don't have that in England and Wales, but you can see the differences. Now, we're not suggesting, and I wouldn't be at all suggesting, that we're looking at interfering with the individual ways in which countries themselves decide both on the type of offence they recognise as a criminal offence and the sanctions imposed, although we do have the membership of the EU which specifically precludes capital punishment or judicial homicide, as I would prefer to call it, where the state kills people. And that, of course, we do not accept. America, Indonesia and other countries, please note. Especially China, which I didn't include. Now, being a barrister, getting off that subject, the author Troy Anderson has written this book specifically for fellow practitioners and students too, by presenting in a succinct and accessible manner the type of information that practitioners need to know in order to advise clients and present matters in court. So it's got a hands-on, very much a hands-on approach. And I can't speak, of course, for the Australian bar, but I'm sure from what I've seen that this would be an excellent guide for any advocate. With its practical approach, then, the book will obviously be of particular interest to practitioners involved in cross-border and international criminal cases. And we're going to get a lot more of this happening. And, of course, what we then see are the failings, in some cases, of the way in which some countries handle criminal matters, which, of course, then leads to the clamour, if you like, and the representations that are made to see if we can try and get some general agreement on what is and is not an offence. And I think with the very major and heinous of crimes, there isn't much doubt as to what constitutes that sort of offence. And the question then is how you deal with it in terms of the sentencing and the law enforcement options. And that, of course, is where there are major diverse opinions. It's important to note, I think, with this book that there is a useful table of cases and statutes. They are at the front, and they're, of course, a very extensive and helpful index at the back. Let me conclude by saying we've not really reviewed many Australian titles before. I was very impressed with this book. I can see that the publishers are very serious in what they're trying to do, and I commend them because they produce something, I think, which will be of great assistance to practitioners. Concluding, I would say, as investigations into criminal activity, especially corporate crime, for instance, are now conducted more often than not across several countries or worldwide, this book then presents valuable insights and much enlightened comment and information for the benefit of international lawyers everywhere. And as I say, the publication date is cited, I think, as at November 2014, and I'm recording this in April 2015. I'll just show you the book again. It's a light book. It is a hardback, lovely cover, nice pages as well. It's very well presented as a book. There is a paragraph numbering, makes it very easy to find things. Not too much footnoting, which I'm grateful for. A lot of detailed information. You can see again the structuring of the index itself. It has the paragraph numbering. That's on sentencing there, for instance. And then you've got, again, quite a substantial amount of stuff in the index. Then at the front, if I can just remind you again, there's the table of cases. And again, you see this is all very much a part of the Commonwealth, but I think, again, from our point of view in England and Wales, this is a very important book. Thank you, Troy, and thank you, Federation Press, very much indeed. This has been a book that we have found a joy to review. I think it's a very important book, and I hope that you will find the assistance you're looking for by going through it. Thank you very much to all concerned. Bye-bye.